James and Jennifer Crumbley, the parents of the teen who shot and killed 4 people and injured 7 others at Oxford High School back in 2021, have been dropped from a civil lawsuit brought by the victims and their families.
Ven Johnson, whose law firm brought the case against the Crumbleys in Oxford Community Schools, says this allows for a quicker appeal against the decision made earlier this year, which ruled Oxford employees are protected by governmental immunity.
And Ven Johnson is here with us tonight to explain that decision. Thanks for joining us, of course.
My pleasure. Thanks for having me.
So tell us the process. What factors led up to this choice?
Well, when Judge threw out our case against the Oxford defendants, it's not what we call a final order, you guys. And what that simply means is, in order for us to appeal to the next court up, which is the Michigan Court of Appeals, I don't have an automatic right to do that until the case is fully over. Well, the case couldn't be fully over because we still had Crumbley and the 2 Crumbley parents in the case too. Therefore, that means the only thing I could do is what's called a leave application. In other words, dear Court of Appeals, may I appeal? And then we would sit with nothing happening. It's called a stay. It's where the trial judge wouldn't let us do anything for over a year, you guys, and not even know whether the Court of Appeals was going to hear it or not. So after that year or year and a half, they may say, no, we don't want to hear it right now. Then I'd have to go back to the trial court and still deal with the Crumbleys. So what we decided to do was we filed a motion for what's called voluntary dismissal. And so on the 13th, I believe, Wednesday the 13th, 10th, excuse me, we will be arguing that motion to Judge Brennan, and I don't think there won't be any opposition. The Crumbleys certainly haven't taken any role whatsoever in this litigation, and Judge Brennan will likely grant that motion. Then when she enters that order, which is a big piece of paper, it says case is now closed. Then I can file the automatic right of appeal to the Court of Appeals on Judge Brennan's decision to throw out all the Oxford people. I know I'm taking you guys in the legal weeds tonight, sorry, but that's the gist of it.
The school saw warning signs from Ethan Crumbley multiple times, and they even alerted the parents.
Absolutely.
So there's lots of finger pointing, and it's easy to sit here and point the finger after the fact. But how is it possible that the school cannot be held liable?
Well, I ask you that and ask our audience that, because the only answer is because Michigan's governmental immunity laws is what the judge ruled precludes that, stops you from doing that.
And could that law get overturned?
That's what we are arguing. That's one of the things we'll argue to the Michigan Court of Appeals. And no matter which way the Court of Appeals goes, y'all, then we or the other side will be appealing to the Michigan Supreme Court for absolute sure. So all I can tell you is we will be arguing that to 2 appellate courts here in the next 2 to 3 years.
The victims and their families who you represent, what has their reaction been? How do they feel about having to separate the parents out of this case?
The Crumbleys, obviously, certainly, and we've said from day one, the reason why we brought the lawsuit was for full accountability for everybody of everything that went wrong that day, so we could learn valuable lessons about how to prevent this from happening ever again. So in this particular case, so they wanted to hold Crumbleys responsible. I sued them. However, now it's kind of blocking our ability to get that automatic right of appeal, to make that appeal go faster, in other words, in a year to year and a half instead of 3 to 4 years. So they've allowed me and given me permission, we call it authority, to dismiss the case against the Crumbleys and to move forward against the school, and the school, not just the school itself, but obviously the individuals who were working at the school that we sued.
The parents have been charged with involuntary manslaughter.
Right.
How do you see this playing out here in this situation?
Well, the Michigan Court of Appeals in the criminal case has recently ruled that the trial judge did the appropriate things in binding over them for trial. So that means they're going to go back to the trial court now, and they're going to get a trial date. And we're going to hear about that. Obviously, I would expect it to be sometime over the course of the summer or really early fall. But we're going to hear about that, I think, relatively soon, guys.
Do you expect a separate civil suit to be filed against the Crumbleys?
I don't. Now that we're seeking to dismiss them, what's called with prejudice, that simply means I can't sue them again. So if Judge grants our motion in 2 Wednesdays, they'll be, as it relates to my clients, they'll be never in the suit again. So if we win in Court of Appeals or Supreme Court, reverse and go back to trial, it would solely be against Oxford Community Schools and the individual teachers and principal and so forth, if you will, the assistant principal that we sued.
I'm trying to understand this. Why can you not go after the parents? Because they bought him the gun and they knew of some of the mental health issues going on.
Is it just a result of this legal maneuver you're having to pull?
Answer is, I did sue them, and I've sued them now for, what is it, a year and a half. But now, yes, because it blocks me from getting a automatic right of appeal. Understand this, guys, it should have been on the other foot. Had Judge Brennan said, oh, no, Johnson, you're right, this case goes to trial in school district, you're still in the case, they would have had an automatic right of appeal. But in the same situation reversed, we don't have one. Governmental immunity gives it to them. Special Supreme Court rule that allows for that. And you say to me, how can our government, who works for us, have special rules and get favor under the law? And the answer is exactly. That's why governmental immunity needs to be thrown out, y'all.
We will see what happens with that. And just to really underline the point here, the reason the parents are being dropped off is not for any lack of evidence. It isn't for any minds or hearts have been changed. It is simply because of this legal maneuver.
Correct, yes. And they are being held accountable in the criminal case. So now, since the school and the school officials have not been charged criminally, the civil case will go on and focus on their conduct.
Can't imagine what the parents of the victims are going through, and
they're horrible.
Now with this legal battle continuing to go on, you really feel for those families and
Thank
loved
you.
ones.
We appreciate you.
Well,
thank you guys
for coming in
Thanks
tonight.
so much for joining us.
Thank you.